There is a quiet, devastating assumption made by millions of hardworking people who cross the threshold of their 60th birthday. You have paid off your mortgage, or you are very close to it. You hold the deed to your home, you have a checking account, a modest retirement fund, and you sleep soundly believing that because your name is on the title, your property is safe and your children's inheritance is secure. But there is a hidden reality, a mechanical, highly efficient bureaucratic system operating in the background of our society. And it is explicitly designed to strip that asset away from your bloodline the moment your cognitive function slips or your heart stops. The estate planning industry, the banking sector, and the probate courts are legally forbidden from actively reaching out to warn you about this, and frankly, they have no financial incentive to do so. The system you are trusting is built to work quietly against you, feeding off a widespread, totally innocent mistake that destroys families every single day. Most people have never heard of the specific legal mandates that authorize state governments to seize a primary residence, nor do they understand the catastrophic danger of relying on a simple last will and testament. Today, we are going to tear back the curtain on a deeply uncomfortable truth. If you own your home and you are over the age of 60, you are standing on a financial landmine. And if you do not file 5 specific documents before your health begins to fail, the wealth you spent 40 years building will not go to your family. It will be cannibalized by court fees, liquidated by state recovery programs, and drained by court-appointed strangers. To understand the sheer scale of the danger you are in, you must first understand how weaponized the legal system becomes the exact moment you are no longer able to speak for yourself. We have been conditioned by television, movies, and outdated legal advice to believe that a standard will is the ultimate shield. You go to a local lawyer, you pay a few $100s, you declare that your house goes to your son and your daughter, you sign it, and you put it in a fireproof safe. You think you have done the responsible thing. You think you have protected your family. But a will is not a shield. A will is merely a ticket of admission to a courtroom. It is a set of instructions written to a judge, and it guarantees, absolutely guarantees, that your grieving family will be dragged into the notoriously slow, expensive, and public machine known as the probate court. When you pass away with only a will, or worse, with nothing at all, your assets do not smoothly transition to your heirs. Your assets are immediately frozen. Your house is frozen. Your bank accounts are locked. And your children must now hire an attorney out of their own pockets just to ask a county judge for permission to access what you already said was theirs. The financial bleeding begins almost instantly. In many jurisdictions across the country, probate attorneys and executors are entitled by statute to take a percentage of the gross value of your estate, not the net value. This is a critical distinction that bankrupts families. If your home is appraised at $500,000, but you still owe $100,000 on a reverse mortgage or a home equity line of credit, the probate fees are calculated on the full $500,000. Between statutory attorney fees, court filing costs, mandatory appraisal fees, and executor bonds, the probate grinder routinely consumes anywhere from 4 to 8% of an estate's total value. We are talking about tens of thousands of dollars evaporating into the pockets of the legal establishment simply to process paperwork. And while this money is bleeding out, time is standing still. The average probate process takes anywhere from 12 to 24 months to resolve. For 2 years, your children cannot legally sell your house, but they are still legally required to maintain it. They must pay the property taxes, the homeowner's insurance, the utility bills, and the maintenance costs, all while navigating their own grief. If they cannot afford to keep the lights on and the taxes paid for 2 years out of their own pockets, the home goes into foreclosure and the bank reclaims the asset. The wealth you broke your back to build is simply wiped off the map because you relied on a document that forced your family into a rigged game. But the horror of probate is only one facet of the danger, and frankly, it is not even the worst-case scenario. Probate only happens after you die. What happens if you do not die? What happens if tomorrow morning you suffer a severe stroke, or you are involved in a catastrophic car accident, or the slow, creeping fog of early onset dementia reaches a point where you can no longer balance a checkbook or recognize your own signature? This is where the trap snaps shut on the living. If you lose your cognitive capacity without having established the proper legal barricades, your family cannot step in to help you. Your spouse cannot simply walk into a bank and demand to pull money from an account that is only in your name to pay for your medical care. Your children cannot list your house on the market to fund an assisted living facility. Because they do not have legal authority over you, they are forced to initiate one of the most draconian, invasive, and humiliating legal proceedings in the modern justice system: the adult guardianship or conservatorship process. Your own children will have to hire a lawyer to sue you in court, publicly declaring you legally incompetent. They will have to bring medical records into a public forum to prove your mind has failed. And the judge, acting in what the system considers your best interest, is not obligated to give control to your family. In an alarming number of cases across the country, judges will appoint a third-party professional guardian, a complete stranger, to take total control of your life. These court-appointed guardians have absolute authority. They decide where you live, what doctors you see, what medications you take, and they have complete, unchecked access to your life savings. And here is the truly terrifying part. This stranger charges your estate by the hour. Every time they answer an email from your daughter, your estate is billed. Every time they review your bank statements, your estate is billed. Every time they file a mandatory report with the court, your estate is billed, often at rates exceeding $300 an hour. Your family is entirely locked out of the decision-making process, forced to stand behind a pane of legal glass and watch as a court-appointed operative slowly drains your life savings to pay their own administrative fees, eventually selling your home out from under you just to keep their own billing cycle funded. The system actively alienates your loved ones, substituting family bonds with cold, billable hours. And if you manage to avoid the conservatorship trap, there is an even larger predator waiting in the wings, backed by the full force of the federal government. It is perhaps the most heavily guarded secret in the entire financial sector, a mechanism created by the Omnibus Budget Reconciliation Act of 1993. Most Americans have absolutely no idea this legislation exists until it is too late. It is called the Medicaid Estate Recovery Program. As we age, the reality of requiring long-term care or nursing home support becomes statistically unavoidable for a vast portion of the population. People assume Medicare will cover these costs. That is a fatal misconception. Medicare does not pay for long-term custodial care in a nursing facility. Medicaid does. But Medicaid is not a free entitlement program for the elderly. It is, for all intents and purposes, a loan. When you apply for Medicaid to cover the staggering $10,000 to $15,000 monthly costs of a nursing home, the state steps in to foot the bill. But the moment you pass away, federal law legally mandates that the state government must attempt to recover every single penny they spent on your care. And how do they do that? They look directly at the single largest asset you leave behind: your home. If your home is sitting exclusively in your name or merely governed by a standard will, the state's recovery unit will place a massive lien on your property the moment your death certificate is filed. Your children will receive a formal letter in the mail, often mere weeks after your funeral, presenting them with a bill for hundreds of thousands of dollars. They are given an ultimatum: either write a check to reimburse the state for your years of nursing home care or surrender the house. Since very few families have $250,000 in liquid cash lying around, the state forces the sale of the home. The government takes the proceeds to settle the ledger, and your children inherit absolutely nothing. The family home, the place where you celebrated decades of Thanksgivings, the physical embodiment of your life's labor, is auctioned off to a real estate developer because you did not build a legal fortress around it before you got sick. The state is not evil for doing this. They are simply executing the law as it is written. The tragedy is that the system banks on your ignorance. They rely on the fact that you will not take preemptive action to shelter your most valuable asset from their inevitable collection efforts. The friction between what we assume will happen and what the legal system actually enforces extends deeply into our medical lives as well. Imagine a scenario where you are suddenly hospitalized, unresponsive, and hooked to a ventilator. Your family rushes to the intensive care unit. In an ideal world, the doctors pull your spouse and children aside, and together, out of love and mutual respect, you all make decisions about your care. But the modern medical legal complex does not operate on love and respect. It operates on risk management and liability mitigation. If you have not legally documented your exact medical wishes, the hospital's legal department takes the reins. They will default to preserving life at all costs, regardless of your personal desires or the excruciating pain it might cause you, simply to avoid a wrongful death lawsuit. Furthermore, if there is even a hint of disagreement among your children, if your eldest son believes it is time to let you go peacefully, but your youngest daughter, overwhelmed by grief, demands that they keep you alive on machines indefinitely, the hospital will freeze. They will refuse to act. The doctors will retreat, the lawyers will step in, and your children will be forced to wage a bitter, traumatic legal war against each other in a hospital hallway while you lie unconscious in a bed. Friendships between siblings are permanently destroyed in these moments. The guilt, the resentment, and the financial burden of keeping you in a state of artificial suspension will haunt them for the rest of their lives. Even the basic mechanics of modern banking and digital infrastructure are actively working against your family's ability to recover your assets. We live in an era of paperless statements, two-factor authentication, and biometric security. 20 years ago, when someone passed away, their executor could just wait for the mail to arrive, open the bank statements, and figure out where the money was. Today, your financial life is trapped behind passcodes, facial recognition, and encrypted servers. If you die unexpectedly and your phone is locked, your children are locked out of your life. They cannot access your email to find out where your investment accounts are held. They cannot access your digital portals to pay your final bills. And if they call the bank will refuse to speak to them, citing federal privacy laws like the Stored Communications Act. If an account remains dormant for long enough because your family literally does not know it exists, the bank is legally required to hand the money over to the state's unclaimed property division. Every single year, billions of dollars are absorbed by state governments simply because the heirs had no idea the accounts existed and lacked the legal authorization to unlock the digital vault. We have spent this time mapping out the battlefield, understanding exactly how the system is designed to paralyze your assets, drain your wealth, and subject your family to unbearable stress. The legal structure of our society dictates that if you do not actively take control of your estate, the state will assign a default plan for you. And the state's default plan is public, expensive, agonizingly slow, and devastatingly efficient at vaporizing generational wealth. But here is the critical turning point. You do not have to be a victim of this machine. You can entirely opt out of the probate system, bypass the conservatorship trap, legally shield your home from Medicaid recovery, and ensure your family experiences a seamless, private, and instantaneous transfer of power and wealth. It does not require you to be a multimillionaire. It does not require endless months of legal wrangling. It requires you to file 5 specific, immensely powerful legal documents. These are the tools the wealthy have used for generations to protect their dynasties, and they are entirely available to you right now. The first and most critical document you must execute is a revocable living trust. If you take nothing else away from this, understand that a will guarantees probate, but a trust entirely bypasses it. When you create a revocable living trust, you are creating a legal holding company for your life. You take the deed of your home, your bank accounts, and your investments, and you transfer the ownership from your personal name into the name of the trust. You remain the supreme trustee. You maintain absolute 100% control over everything. You can sell the house, spend the money, or change the rules of the trust at any time while you are alive and competent. To your daily life, absolutely nothing changes. But the magic happens the second you pass away. Because you, the individual, legally owned nothing at the time of your death. The trust owned it all. There is nothing for the probate court to process. Your estate does not freeze. The person you named as your successor trustee, usually your spouse or your child, instantly steps into your shoes. They can walk into the bank the very next morning, present the trust document and your death certificate, and immediately access the funds to pay for your funeral. They can list the house for sale that same week. The entire process is private, immediate, and costs exactly $0 in probate court fees. You have effectively built an invisible, impenetrable wall around your assets, keeping the lawyers and the judges completely out of your family's business. The second document you must urgently file is a comprehensive durable power of attorney for finances. This is your shield against the nightmare of court-ordered conservatorship. This document legally appoints someone you trust implicitly to manage your financial life if you lose cognitive capacity. But the critical word here is durable. A standard power of attorney vanishes the moment you become incapacitated, which is exactly when you need it most. A durable power of attorney remains in full legal force even if you fall into a coma or develop severe dementia. With this document in hand, your chosen agent can pay your mortgage, manage your investments, file your taxes, and protect your assets without ever having to ask a judge for permission. They can step in immediately to keep your financial life afloat, completely neutralizing the threat of a court appointing a stranger who bills your estate by the hour. The third document is the definitive countermeasure to the Medicaid Estate Recovery Program. And depending on your state, it comes in the form of an enhanced life estate deed, commonly known as a ladybird deed, or a transfer on death deed. This is a highly specialized piece of real estate law that fundamentally alters how your property transfers. When you file this specific deed with your county recorder, you are essentially naming a direct beneficiary for your home, exactly like you do with a life insurance policy. You retain total ownership and control of the house for the duration of your life, but the exact millisecond your heart stops beating, the property legally transfers to your children. It never enters your probate estate. Because the home transfers instantly outside of probate, the state's Medicaid Recovery Unit cannot place a lien on it. The house is gone before the state can even draft the paperwork to claim it. By spending perhaps $200 to file this single deed, you can legally protect a $500,000 asset from being seized by the government to pay for your nursing home care. It is arguably the most disproportionately powerful legal move a homeowner over 60 can make. The fourth essential document is a rock-solid advanced healthcare directive combined with a HIPAA authorization form. This completely eliminates the hospital hallway wars that destroy families. This document does two vital things. It clearly legally states exactly what life-prolonging measures you do and do not want, taking the agonizing burden of choice entirely off your children's shoulders. They never have to live with the guilt of deciding when to pull the plug because you already made the decision for them. Secondly, it names a specific medical proxy, one single person whose voice has the ultimate legal authority to direct your medical care, overriding the hospital's legal department and any dissenting relatives. The attached HIPAA authorization is equally crucial. Without it, federal privacy laws prevent doctors from legally discussing your medical condition with your own family. This single packet of papers forces the medical establishment to respect your dignity and keeps your family united during the darkest moments of their lives. The fifth and final document is perhaps the most modern requirement, yet the most frequently overlooked: a comprehensive letter of instruction with a digital asset authorization. A trust and a deed are useless if your children cannot find them, or if they cannot unlock your digital vault. This is not a formal legal document filed with the county. It is an intimate, highly detailed roadmap of your life. It lists the exact locations of your trust documents, the contact information for your attorney and CPA, the login credentials for your password manager, the PIN codes to your phones, and the locations of any hidden physical assets like safe deposit box keys or precious metals. Furthermore, you must ensure your state-specific legal documents contain a digital assets clause, explicitly granting your successor trustee the legal right to bypass the Stored Communications Act. This forces tech companies and banks to grant your heirs access to your email accounts, digital wallets, and online banking portals. Without this, your financial footprint could vanish entirely into the digital ether. These 5 documents, the Revocable Living Trust, the Durable Power of Attorney, the Specialized Transfer Deed, the Advanced Healthcare Directive, and the Digital Letter of Instruction, form an unbreakable legal architecture. They take less than a few weeks to establish, yet they solve the most agonizing, expensive, and destructive problems your family will ever face. But there is a final, vital truth we have to address, and it strikes at the core of why so many people fail to take these steps. We are deeply uncomfortable with our own mortality. We avoid thinking about our decline, and out of a deeply misguided sense of love, parents often choose silence. They think, "I love my kids, we get along great. I will just leave the house to them in my will and let them sort it out. I don't want to burden them with morbid conversations right now." You must understand that this instinct, while born of love, is the exact mechanism that causes catastrophic harm. Silence is not a shield. Silence is a trap. By avoiding these minor administrative tasks today, you are actively choosing to subject your children to the brutality of probate court, the invasive humiliation of conservatorship, and the absolute devastation of seeing their childhood home auctioned off by the state. You are leaving them to navigate a bureaucratic nightmare precisely when they are drowning in the grief of losing you. Real love is not avoiding the hard things. Real love is looking the inevitable in the eye and building a fortress to protect the people standing behind you. Putting these 5 documents in place is the ultimate act of parental devotion. It is you reaching out from beyond the inevitable to say, I took care of this. You don't have to fight. You just have to mourn and heal and remember me. If you are watching this, you now possess the knowledge that the system relies on you not having. You understand the traps, and you hold the map to navigate around them. But knowing the path is useless if you do not walk it. I ask you, right now, to think about the people in your life who need to hear this. Think about your parents, your older siblings, your closest friends who are blindly trusting a system that is rigged against them. You have a profound, urgent moral obligation to share this reality with them before the window of opportunity closes. Send this directly to them. Sit down with them at the kitchen table, look them in the eye, and start the uncomfortable conversation. Tell them you are doing it because you love them too much to watch their legacy be dismantled. Take action. Build the fortress. Protect your bloodline. You have the power to secure your family's future, but only if you act before it is too late.